The National Labor Relations Board, private sector, is comprised of a team of professionals who work to assure fair labor practices and workplace democracy nationwide. Since its creation by Congress in 1935, this independent federal agency has had a daily impact on the way America's companies, industries, and unions conduct business. The NLRB staff members investigate and remedy unfair labor practices by unions and employers. What is an unfair labor practice? ULP. An unfair labor practice in the United States labor law refers to certain actions taken by employers or unions that violate the National Labor Relations Act of 1935 and other legislation. Such acts are investigated by the National Labor Relations Board, the NLRB. Here's a link where you can find the violations. Here are a few examples of unlawful employer conduct. Unilateral changes. This is a policy or rule that is instituted without consulting the union. The change violates Section 8A.5 of the National Labor Relations Act, the NLRA, or a similar provision in the public sector collective bargaining law. The National Labor Relations Board can order the employer to rescind the change, compensate employees for any lost wages or benefits, remove any discipline imposed as a result of the change, and bargain in good faith before reinstituting the policy or condition. Coercive questioning of employees regarding their union activity. Threatening employees or discriminating against employees because they participated in union activities. Promising benefits to employees if they refuse to participate in union activity, or failure to bargain in good faith. How to file an unfair labor practice, ULP. Unions can file an unfair labor practice charge with the NLRB up to 6 months after illegal employer conduct. Forms are available on the NLRB website at www.nlrb.gov for private sector unions. Deferral policy. Under the policy called deferral, regional directors can suspend action on union-filed ULP charges if the employer agrees to resolve the matter through the grievance procedure. The NLRB justifies deferral as a way of conserving its resources. However, the NLRB does not defer ULP charges alleging the failure to provide information. Union representatives are entitled to certain information when they are investigating grievances or disciplinary cases. If an employer refuses to release certain information, that is a major charge with the NLRB. Violation of Weingarten rights. If an employer refuses anybody their right to union representation when they requested it and they are being investigated for a disciplinary case, that is a major charge with the NLRB. And lastly, retaliation for any labor board charges. Purchase this book, The Legal Rights of Union Stewards by Robert M. Schwartz, to learn more about the National Labor Relations Act, unfair labor practices, and much, much more. Here's the link where you can buy the book. That is the end of our presentation on the NLRB and PERB. Thank you so much for watching. Please visit Smart University for more videos. Thank you and take care.